private inspection initiative until next year. This is what we are conversing with our panelists here. And just to prime you as we continue with that, we were also expecting to be joined by Duncan Mathenge, who has not shown up, but we continue pace, as always, with the conversation. Harrison Kinyanjui, advocate of the High Court, and also Wilberforce, who is a member of Parliament, Funyula. We continue with where you'd left, I think, before we went to Mheshimiwa. You wanted to interrogate deeply and drill deeper on the issue. Was it legislation bit of it? Mm-hmm. Just you can continue.
Yes. Now, when you look at the constitutional manner of making legislation, this is called subsidiary legislation. The Minister for Transport is given the statutory power by both the Constitution and Parliament to then come up with the rules. But then there is a law that governs how you make, incept, and legalize those rules. Now, Section 11 of the Statutory Instruments Act, subsection 1, demands that when a minister makes those rules, in this instance, there were 2025 inspection rules, which were dragging in school motor vehicles, public service vehicles, and now these private motor vehicles. They were supposed to lay before the National Assembly. What does laying before the National Assembly means? It means that once the Cabinet Secretary then publishes in the Kenya Gazette, causes the publication to be made in the Kenya Gazette, they are then supposed to forward that to the clerk of the National Assembly, who then receives and stamps. That is now called the tabling, because the clerk then will forward these to the Speaker and then approved for tabling before the House. Why? So that the Transport Committee that is responsible for this can have a look at that, together with the Legal and Constitutional Affairs Committee, to look at the legality. Do these regulations and rules, for instance, contravene the Constitution? Yes, they do. Once there is a finding that yes, they do, the minister then has to be informed that this is not viable. There is sometimes a committee report. Now, Section 11, subsection 4, and this is very fundamental for Kenyans to know. If those regulations were not laid before the National Assembly, the law says they cease to have effect within the period they were supposed to be laid, that is 7 days of being published. Let me use a typical example. When such a law is incepted without public participation, Kenyans being informed that this is how this is going to happen, although the NTSA alleges that there was a court case in which the Honorable Lady Justice Maureen Odero had said that there was actually an impact assessment report by the NTSA. But I would have interrogated, okay, fine, if there is such an impact assessment report, does it agree with the demands of the Statutory Instruments Act? How many of these drivers did you meet to inquire from them that, look, how will these regulations impact you financially, in terms of convenience, your time, or the efficacy? I don't know if that was ever interrogated, so I cannot go into it. So the Kenyan people, if they are not consulted to participate, then obviously the whole gamut of regulations is null and void. Now, on the legality of this issue, and I have to emphasize without wishing to sound redundant and repetitive, these instant fines that the NTSA is communicating to your phone through an entity called Pesa Point. This
Pesa Print.
Pesa Print. Pardon me. Pesa Print is not recognized as under the Constitution as an entity known as a consolidated fund to receive money on behalf of the NTSA. So if the NTSA is collecting money as an entity by itself, it's supposed to be receiving that money by itself. But it cannot subdelegate. It cannot then, because the National Assembly, the Parliament has said that then these entities, these state agencies, semi-autonomous state agencies can then collect that money for their functional use. But they have no mandate to subdelegate that to these entities that are private in nature, who have absolutely no accountability to the Kenyan people directly.
The same what was happening with KPLC, you may remember?
Yes.
With the tokens.
Absolutely.
Right?
Yes.
It was not really directly coming from KPLC. And
Yes.
I think there was a huge scandal around it.
Yes.
That Kenyans now wanted to, was there a class action suit against KPLC, if you may remember, around 2018?
Yes.
Yeah?
Yes. Yes.
It's the same scenario that we're seeing here, that you have a third party or,
Yes.
you're collecting on behalf.
And now the Kenyan people need to know,
Yes.
this Pesa Print company has been given a 21-year, 21, you people ought to interrogate this honestly and fairly to in terms of accountability to the Kenyan people. Because if these documents are entered into in such deep secrecy, because you do not know how much of that money that they will be retaining, how much of that money they will be then forwarding, quote unquote, to the NTSA, and how much money they will be, quote unquote, expending as for their operations. So that opacity is what offends the Constitution, because then Article 10(2)(a) of the Constitution says that you have to do everything within the principle of transparency. And then Article 10(2)(c) of the Constitution ends with the principle, the value of good governance. Mm. So you ask yourself, why would the NTSA engage in that sort of a thing, except and only if they are not being, engaging in acts of corruption, or at least lining someone's pocket.
Right.
So in the end, the National Assembly, I think, bears heavy responsibility to inquire into that. And then we are supposed then to say, this is not possible. But you find these so-called PPPs. And they need to go back to that, procurement law. They need to go back to that. If you look at Section 7, for instance, says the sale of government shares is not subject to the public procurement. The government bought those shares using your tax money, my tax money. So how can you say that this is no longer subject to the law that governs public procurement? But that's it. That's what they say.
Right. So the procedural propriety has to be there, even of course with that procurement as well. That needs to be interrogated, Mheshimiwa. Unless you want